Hi everyone, welcome to my channel. This is your Govindraj. Thank you very much for watching my videos and sharing to your contacts, your likes and subscriptions. And in this video, I'm going to make an argument on the labor codes. Whom do they help, whether the employers or workers? Because we certainly know that the government will implement the labor codes despite employers asking for a few changes, and look at the unions, they are also asking for a fresh discussions, and the government is telling that the tripartite consultation and discussions are over, and the government is making for all preparation to roll out these four labor codes and much ahead of their schedule, because originally the schedule is for 1st April onwards. Now the government is also telling that the labor codes may have a chance of getting implemented much before the scheduled time. And now in this video friends, let us critically examine on this topic. Whom will they help? Do employers are going to get benefit, or do workers are going to get benefit, or these labor codes, do they balance the rights of the employers and or rights of the workers? Basically, do they balance the rights of both the workers and employers? So to proceed with this topic, we need to list out, because of the labor code and labor reforms, what employers got and what workers got from these labor codes. And naturally, let's take the case of workers in the first instance and look at what workers got today. See, if you look at the entire labor codes, if you critically examine all the four labor codes, the century old demand for mandatory recognition of trade union is now the legal right of workers. And also, today, the collective bargaining has received the statutory status which was originally based on unity and struggle. Now, also, unions may get certain facilities from the employers for conducting trade union activities, and the fixed term employees also now have got the right to receive gratuity on a pro rata basis. And look at so called unconventional non-traditional workers like gig workers and platform workers. These employees also are brought under the labor codes, and the government will roll out social security schemes for these people also. There are certain regulatory requirements are coming up in the labor codes and the rule making process, and employees in all the industrial establishments now are brought under labor codes, and certain basic rights are ensured in the abstract of the law itself. Because if you look at the provisions, issue of mandatory appointment letters and mandatory medical examination for employees over and above the age of 45 years of age, all these basic conditions are in the labor codes abstract of the law. And look at also in the case of retrenchment, additional 15 days wages in the name of reskilling in case of retrenchment is also provided. And look at how the individual grievances are getting resolved going ahead. See, these individual grievances are set to address internally in the company, and if the internally, because of the grievance redressal committee is unable to address, then these individual grievances can also reach conciliation and adjudication as well. And let's look at another important thing what workers got. Thanks to the wage definition and its complexities, and all the four labor codes have the similar definition of wages, and because of this wage definition, the employees or workers are expected to get more provident fund and other social security benefits depending on the what is the current structure of the employer and what is the employer has maintained so far, the structure and components. And government welfare measures are expected to go digital to benefit employees directly and to avoid pilferage. So these are the few of the things which I highlighted, and there are many things as well. And for our discussion, these things are enough. Now, Having told that what is the green side of the labor codes, we also have to see the black side of the story, or which is not so good story in the case of or in the interest of workers. Now we talked about fixed term employment concept, and if this is accepted by the courts in the same spirit, what will happen? Because the regular jobs in the country or permanent jobs in the country are going to erode if the fixed term concept in the same spirit is accepted by the courts of India. And a major portion of employers is now armed with a weapon to close down their establishment without any restrictions or permissions. And why I'm telling you this, because if you look at the industrial relations code, now the permission which was required for layoff and retrenchment and closure for 100 and above industries, now that threshold is now 300 or more. So the majority chunk of the employers are going to come within this threshold limits. And let's look at another thing. Terms of employment of the majority of the workforce are left in the hands of employers. Why am I saying is this? Because now the employment standing orders is also going to applicable for establishments having 300 or more workers. So this means the employer will decide the terms of employment of the majority of the workforce, because major chunk of the employers are going to come in this threshold. And look at how today the offenses are getting dealt. The decriminalization possibilities will let the employers be more casual towards labor laws, and the compliance to labor laws may not be so stringent or so accurate or so legally bound. And to conclude, if on this workers topic, if the labor laws cannot create a long time employment and terms of employment are not regulated and businesses are open to close down, then how does labor codes are going to help workers? So this is the conclusion which I'm going to make on this topic. Now, so this is the brief story of workers. Now let's look at the employer's case. And naturally, to make an employer's case, we also need to look at what employers majorly got because of the labor codes. And first of all, compliances are said to be easier and digital, and the number of registration is said to reduce. And as I said already, the major portion of employers are not required to comply with the provisions of standing orders, and the major portion of employers can easily close down their business without getting into permission and restrictions, which I already talked about in the workers case. And employers are also allowed to hire fixed term workers, as this is now an exclusive provision. Whether the courts will accept the same spirit or not, we have to check in the future. So however, these provisions are brought. And look at how the offenses are getting handled. Decriminalization of offenses is brought so that employers are safeguarded from going to jail for majority of the offenses. And look at how the non-compliances are getting handled. Employers are required to be given the opportunity to correct the non-compliances before going ahead on the prosecution, and web-based inspection and self-certification will all become reality. And these are the few things which I have talked about it for our argument's sake. And meanwhile, the story doesn't get completed if we don't see the other side of the story. So let's look at the black side of the story, which is not in the interests of employers. Now, even though this, as I said, the fixed term employment is allowed, there is always an apprehension that do courts of India accept this spirit? And this apprehension will always be there as long as there is no interpretation from the courts. And there is no free flow to hire contract employees in the core activities, which was very much available currently, if the state government or the appropriate government has not prohibited the employment of contract labor in core activities. So now this is being taken away, and the riders are fixed for employment of contract workers on core activities, and it is straight away prohibited. There are certain exceptions are available, but they are ifs and buts, and that's not going to help the employers. And thanks to wage definition and its complexity, now the cost of production tend to increase because the portion of wages which is applicable for social security benefit is going to increase, and depending upon the structure what the employer has got, and his liability depends, and it can increase and it can also remain same. And moreover, the provisions give way for more bureaucratic interventions which may allow for corrupt practices. There are many things, because even today the offenses are also now getting inquired from the executive machinery. So these are very important, certain provisions are there in this way. And let's think that if the employer's hands are tied and there is a difficulty to run the business, then what is the use of giving power for him to close down the business? Just ask this question to yourself. And definitely the employer is not interested to close down, rather he wants to take the business for a longer time and more heights. He has not opened his employment for closing down. So therefore there is a requirement of proper balancing is required. Now I'm not going to give you whom do they help, or whether employers or workers. I will leave the judgment to all of you whether this help the employers or workers, or the provisions which are brought, whether they balance both or they don't help anyone. So this is what the judgment, I'm going to leave it to you. And thank you for listening to this argument and this video. And if you like this information, please do subscribe this channel and share it to your contacts, and also don't forget to like the video. Thank you very much friends, and see you soon with the new video and new information.